Contract discharged. If the contract parties have satisfied the requirements of the contract to the satisfaction of each other, a contract is said to be discharged. This is the ultimate result of most contracts. However, there are instances when it may be necessary to discharge completely valid and defensible contracts because of unanticipated events that require it. 12 of the most common reasons why contracts are discharged are provided here, including 1. Full completion. 2. Negative influence. 3. Impossible to perform. 4. Objective impossibility of performance. 5. Cancellation. 6. Rescission. 7. Assignment. 8. Novation. 9. Substantial performance. 10. Partial performance. 11. Satisfaction. 12. Contract alteration. 1. Full completion. As already stated, if both parties have met the terms outlined in a contract and it has been fulfilled, such that it has become fully executed, the contract is discharged. Most contracts are discharged by the parties doing what they promised to do. 2. Negative influence. If a court determines that a contract was signed under duress or as a result of fraud, a significant mistake, or because of undue influence, it may discharge the obligation as a result of one of these negative influences. 3. Impossible to perform. If the promisor of the contract dies, the contract would likely be discharged. A contract with a builder would likely be discharged if the builder was imprisoned for an extended period. However, if the work and/or services may be performed by others who work for the builder, the obligation may survive the imprisonment of the builder. In general, real estate contracts are binding on the heirs and assigns of the deceased. A court may discharge a contract if it finds that the agreement would be impossible for a reasonable person to accomplish. If, however, the builder was imprisoned for just a few weeks, a court may suspend the contract based on temporary impossibility, requiring the contract be fulfilled once the impossibility no longer exists, in this case, after the builder is released from prison. 12. Contract discharge. 4. Objective impossibility of performance. A contract may be discharged if, after it is made, performance becomes objectively impossible. For instance, a property is destroyed by an earthquake or some other natural disaster, or there has been a change in the law that would make the contracted performance unlawful. 5. Cancellation. Suppose Thelma hires a contractor to build a front porch onto her house with an agreement to pay on completion, but the builder never shows up to do the job. If the builder and Thelma agree to cancel the contract is discharged. The same could be said if Thelma paid a portion of the builder's price in advance to have the porch built, and the builder did not show up to do the work, despite his promise to do so. Thelma may decide that it is not worth her time to force the builder to do the work by taking legal action. So she takes the experience as a hard lesson learned and discharges the contract. Would-be buyers make a down payment to secure their option to purchase a property. If after making a good faith deposit, the buyer defaults on his intentions to purchase the property, the seller has the right to keep the earnest money deposit. Doing so discharges the contract by way of cancellation. If, however, the seller feels compelled to give the buyer back his good faith deposit, the contract is discharged by way of rescission. Note: if Thelma later decides to take legal action, the agreement to discharge will likely not be binding because the builder did not offer consideration. 6. Rescission. A rescission is a complete unmaking of the contract and contemplates the restoration of the parties to their original position as if the contract had never existed in the first place. This occurs most often when the parties encounter unanticipated value shifts resulting from a change of heart or ideas. A rescission destroys the entire contract and entitles each party to recover any consideration given to it. Note: should a contract not be legally binding, courts will return the non-liable parties affected to the state they were in before a contract was entered. 7. Assignment. Sometimes, after entering into a contract, one party may wish to withdraw without actually terminating the contract. The assignment is one way of accomplishing this. Assignment results in reassigning rights, duties, and obligations of one party to another person. In general, unless specifically stated to the contrary in a contract, the parties to a contract have the right to transfer their rights, duties, and obligations. When this occurs, the original party maintains secondary liability, similar to a co-signer for a loan. A contract that was established based on unique ability may not be reassigned to another. For example, if a highly sought-after architect was contracted to provide his personal style in the design of a new shopping mall, it is not likely the builder will be able to assign the contract to someone else. Note: most contracts include a clause that stipulates allowance or non-allowance for assignment. If an assignment is allowed, the receiving party maintains liability. 8. Novation. Novation occurs when the parties to a contract and a new party agree to substitute the new party for one of the original parties. Requirements for this action include a previously valid contract, an agreement of all the parties. The old obligation, which discharges the prior party, extinguishes. A new, valid contract. Suppose a buyer determines that he is no longer able to fulfill his duties and obligations associated with a valid contract. After he has communicated this determination to the seller can bind the buyer to the contract. However, suppose that another buyer, unrelated to the first buyer, is willing to meet the duties and obligations of the contract. In this light, the seller may choose to release the first buyer from the contract and substitute the new buyer into the existing contract. Doing so would provide a novation which discharges the first contract and completely releases the first buyer of all duty, obligation, and liability. Note: under ovation, the receiving party is absolved of any legal accountability. 9. Substantial performance. Suppose Juanita asked a contractor to paint her house, including the body and the trim. Before the contractor began the job, he was told exactly which colors to use. The contractor painted the body of the house and then mistakenly painted the trim with a different color than Juanita had asked. In this case, the contractor fulfilled his obligation of painting both the body and the trim, but he did not follow the terms of the contract. Given this outcome, it is likely a court would rule that the contractor's performance qualifies for a discharge of the contract under a substantial performance ruling. Under this rule, Juanita would be obligated to pay the painter for the work, less any damage incurred given the painter's mistake. 10. Partial performance. Suppose Daryl asked a contractor to paint his house, including the body and the trim. Before the contractor began the job, he was told exactly which colors to use. The contractor started the job by painting the body of the house, but then told Daryl that he would not be able to complete the job because of time constraints. Daryl agrees to discharge the original contract and pays the contractor for only half the originally contracted price, using a partial performance as his justification. 11. Satisfaction. To discharge by satisfaction, the parties must agree to accept performance that is different from the performance originally promised. 12. Contract alteration. An innocent party can treat a contract as discharged if the other party materially alters a term, such as price, without first acquiring consent.